We got that dynamite. We got that dynamite.
Find the perfect ride for you today with the New Year New Ride sales event at Guam Auto Spot. Get behind the wheel of the 2024 Outlander Sport starting at just $22,995 or only $156 per paycheck. Visit GuamAutospot.com or call 671-478-AUTO.
Wendy's new Cajun chicken sandwich. So spicy, it's pica.
This tastes oh so good. Say hello to the coolest party in your hands. Cold Stone Guam's birthday cake Oreo cookie ice cream taco. They took everything you love. Birthday cake Oreo cookie ice cream, rainbow sprinkles, rich chocolate, and a crispy waffle taco shell, and turned it into the ultimate summertime celebration. This signature creation won't be around forever, so grab yours while it lasts. Visit Cold Stone at their GPO or Micronesia Mall locations today. Cold Stone Creamery, the ultimate ice cream experience.
Kandit News is brought to you by 76 Circle K Guam.
Good afternoon, my dear friends. It is 4:33 p.m. on Tuesday, July 22, 2025. My name is Troy Torres. And 3 weeks ago, more than 3 weeks ago, a critical public hearing happened that we were not able to cover. I can't remember exactly what happened, but I do remember that the following day, actually I think it's exactly 3 weeks ago that this public hearing happened. Because I think it was the following day that the indictments happened. And so we were unable to cover this public hearing, but this is a critical public hearing to us. This is subjective to us, right? It's on a subject that we've been covering since the beginning of Kandit, and it's the mandatory medical malpractice mandatory arbitration act reform proposal. This has gone through a couple of iterations. At first you had then Speaker Therese Terlahi introduced legislation. It was heavily scrutinized. She produced a compromise version based on what the doctors and the nurses said at the public hearing then. But the doctor and nurses lobby was so powerful that they managed to just kill the bill. And so now comes Senator Will Parkinson in this term, and he produced bill number 82. And Bill 82, as I understand it, is identical to Therese Terlahi, or nearly identical at least, to Therese Terlahi's then Bill 113, if I'm not mistaken, 113 or 112. It's one of those. Anyway, and so he introduced this bill, and it got the same sort of reaction that Therese Terlahi's bill got, the same sort of reception and the same sort of organizing and coordination by the doctors' lobby against this bill. What's different this time around is a couple of things. One, this bill seems to have the support of far more senators. And secondly, and you hear David Lebowski in the hearing talking about, he basically says, look, even if this bill doesn't pass, we're just going to wait for the next legislature and the next governor. And something's going to pass, doctors. There's going to be a version of this that passes. And so you may as well just come to the negotiating table now, sincerely, and with your sincere stated desire that you want the people of Guam, especially the poor and the middle class, to actually have access to the court system. And if doctors, what you're saying that you do want that to happen, you just think that the bill in its present form won't work. If you are serious, if you are sincere that you really want the people to have access to the court system, then sincerely come to the table, stop this politicking, stop this lobbying, stop this organizing that you guys are doing just to kill this bill, and with all your hyperbole and all of that, and come to the table and help to construct something that you think will work for you. And David Lebowski, he puts that out in this hearing. And so, the past 3 weeks, one of those weeks I was on vacation, and then the other 2 weeks really has just been, I just got my bearings back. I'm back at work, but the week prior to that was the indictment. I wasn't able to concentrate on that. So what I'm going to be providing to you now, and until we get all of these testimonies out, is segments of this public hearing. And I'm going to be providing you the segments of the public hearing that come from those who normally are voiceless, those who don't have money, those who, if not for this public hearing process by Senator Telo Taitague, because it was her committee that was put under, but not for this bill that Will Parkinson put out, would not have had a voice in a process like this. And so these are the voices that I want to bring to you. And so we start with Committee Chairwoman Senator Telo Taitague, followed by bill author Senator Will Parkinson. Then there is a doctor who gave testimony, I believe, in favor of the bill, and then David Lebowski. And just as a refresher, David Lebowski is the man who got this whole thing started. This whole look at Medical Malpractice Mandatory Arbitration Act reform. Following the untimely death of his 5-year-old son on October 31, 2018, Mr. Lebowski he pioneered this journey, this campaign, if you will, to reform the Medical Malpractice Act after finding out that the justice system is not available to people who don't have $100,000 to blow on the required medical malpractice that the law right now mandates. And otherwise, you're just out of luck. If you or someone you love is maimed or killed through medical negligence, medical malpractice, you cannot access the justice system according to the laws of Guam built to protect doctors. So without further ado, here is the first segment of our coverage of that public hearing by Senator Telo Taitague.
Guam Code annotated relative to medical malpractice in the territory of Guam, and to cite this act as the Do No Harm, the Anti-Medical Misconduct Act of 2025. Now, before I begin, I ask again for us to enter this hearing with a real commitment to listen with empathy and respect, and that we speak only what is true and genuine. No fabrications, no agenda, just honesty and integrity. This is about real people, real consequences, and our collective responsibility to pursue a system that protects both patients and providers through fair, timely and transparent means. I also understand the urgent need to support and strengthen our healthcare workers and their staff, which is why I continue to explore legislation strategies, such as a measure inspired by Texas House Bill 2852 to bring in internationally trained physicians and expand access to the care of our island. And to clarify for the record, this bill, Bill 82, was referred to my Committee on Justice because it represents a significant shift in Guam's civil liability structure. It seeks to repeal the current mandatory arbitration process in medical malpractice cases and replace it with court-based screening and adjudication model. This legislation concerns access to justice, legal process, and the protection of the constitutional right, not the regulation of medicine. However, I have no issue if this bill was re-referred to the Committee on Health. But in the meantime, I will work closely with the Oversight Chair on Health, Senator Sabrina Salas-Mantanani, on the bill as it progresses. So thank you. And at this time, I'd like to recognize Senator Parkinson. You are now recognized on Bill 82-38. Thank you. Sijusmasi.
Thank you, Madam Chair. Good morning to the people of Guam, members of the committee. Thank you for convening on this important hearing. And I greatly appreciate the opportunity to present Bill number 82-38. I introduced this measure with a passionate commitment to the victims of medical negligence. The victims of medical negligence on Guam, their patients and families who have suffered harm and then found the doors of justice closed. My goal is to balance reform that protects patients without unfairly burdening the medical community. We do not seek to drive any doctors away or diminish healthcare in Guam. Instead, we seek to strengthen trust in our healthcare system by holding accountable those few who do cause harm, while upholding the good reputation of the many honorable physicians who do no harm. Bill 82-38 aims to repeal Guam's mandatory medical malpractice arbitration requirement and replace it with a new pre-screening and litigation process. In essence, it would allow malpractice claims to be heard in court after a fair preliminary review, rather than forcing every victim to pay for private arbitration before they can file a lawsuit. I chose to title it the Do No Harm Act because the status quo is harming patients and eroding public confidence. This reform is about restoring the promise that if you or your loved one are injured by medical negligence, you will have a fair chance to be heard and to seek justice, just as you would anywhere else in the United States of America. To understand the need for change, we must examine Guam's current medical malpractice process. Under Public Law 2143, our island enacted the Medical Malpractice Mandatory Arbitration Act in the 1990s as a response to rising insurance premiums. Today, Guam is virtually the only U.S. jurisdiction that requires every medical malpractice claim go through mandatory and very, very costly private arbitration before a lawsuit can be filed. This is a unique legal barrier one not faced by patients in any state on the mainland. In most cases, a patient can take a doctor to court, sometimes after a simple screening panel or mediation, but no state absolutely forces binding arbitration on all claims as Guam does. In that, we are a country first. What has this meant in practice? For the average person on Guam, the mandatory arbitration law has effectively slammed the courthouse doors shut. Arbitration is so expensive, often requiring hiring 3 arbiters and expert witnesses up front. One analysis noted that just reaching the first step of arbitration can cost tens of thousands of dollars. In fact, it's been estimated that a family may need around $80,000 just to initiate a malpractice case under Guam's current law. Most working families and elders in our community simply cannot afford that. As a result, very few malpractice claims are ever brought forward, even when there is merit. The harsh reality is that if you are harmed by a medical mistake on Guam and you are not wealthy, you likely have no real recourse at all. Guam's mandatory arbitration law, while perhaps well-intentioned when passed decades ago, has become an unfair barrier that protects doctors as a class at the expense of patients' rights. It was supposed to prevent frivolous lawsuits and lower cost, but instead it has prevented all lawsuits, including valid ones, and lowered accountability. As one longtime advocate put it, Guam law has all but prevented negligent, injured, or killed patients from seeking justice like everywhere else in the country, especially economically disadvantaged patients. Bill 82-38 seeks to fix this broken system by implementing a more balanced, transparent, and affordable process for handling medical malpractice claims. And allow me to explain exactly what this bill does and does not do. First, the bill repeals the mandatory arbitration requirement in current law. No longer would every claim be forced into private arbitration. However, and this is very important, the bill does not prohibit arbitration or mediation voluntarily. So if this system is truly working, then the people should have a choice between them. If a patient and doctor prefer to arbitrate or settle out of court, they remain free to do so. And indeed, the court can pause proceedings for mediation or arbitration by agreement. What changes is that arbitration would no longer be a precondition to filing a lawsuit. We remove the paywall to the courthouse. We no longer gate justice behind money. The bill repeals the mandatory arbitration requirement in current law. No longer would every claim be forced into private arbitration. In place of the old system, Bill 82-38 establishes a pre-litigation screening process handled by our illustrious Guam Superior Court. Rather than a panel of private arbiters, a judge will conduct an early review of the evidence in each malpractice case. This is similar to how some U.S. states use medical review panels or tribunals, but we are tailoring it to Guam's needs. Under the bill, when a patient files a malpractice claim in court, it will first go to a special hearing before a judge, essentially an open, neutral evaluation of the claim's merits. Both sides, the patients and the doctors, can present records, affidavits, and expert opinions about what happened. Crucially, the judge can also call a neutral expert witness if needed to help evaluate the case. After reviewing the evidence, the judge makes a finding. Did the health provider deviate from the standard of care? Did the cause the patient's injury? If the judges find the claim is not supported by evidence, the case can be dismissed at its preliminary stage, which protects a provider from a baseless lawsuit. On the other hand, if the judge finds there is a reasonable case of malpractice, the judge will issue a written decision outlining the findings and even a recommended settlement value for the damages. This decision then becomes admissible evidence if the case goes to a full trial. At that point, either party, doctor or patient, who is unhappy with the pre-screening result has the right to demand a jury trial within 30 days. In a sense, it's like an expert-informed probable cause hearing for malpractice. It filters out meritless claims, and for strong claims, it provides an informed evaluation that can encourage settlement or guide the jury. Let me highlight how this new process benefits both patients and doctors. For patients, the important thing is the process is affordable and accessible. Instead of paying tens of thousands to arbiters up front, a patient pays a normal court filing fee and gets a judge to hear their case. If their case has merit, it won't be thrown out just because they couldn't pay arbitration fees. Justice will not be for sale. For the doctors, the process is fair and efficient. Frivolous or unfounded claims can be dismissed early by a judge, sparing doctors the cost and stress of a full trial on a baseless case. This actually strengthens the shield against frivolous lawsuits without denying worthy causes. And that is exactly what we want. Moreover, the pre-litigation hearing allows disputes to be resolved based on facts and expert input, potentially avoiding a protracted courtroom battle if the evidence is clear. If a case does not proceed, the doctor will at least understand the claim's basis from the judge's written findings and can plan their defense accordingly. For both sides, the process promises more transparency. Court proceedings, even pre-screenings, are a matter of record, unlike private arbitration, which happens behind closed doors. This means patterns of negligence can't be as easily hidden. Repeated malpractice by the same provider will come to light, enabling the licensing board and hospitals to take appropriate action to improve care. Conversely, if a doctor is unjustly accused, a court proceeding can clear their name publicly. Transparency is healthy for the entire system. In short, Bill 82-38 does not create a lawsuit free-for-all. It creates a structured, public, and fair pathway for legitimate claims, while still deferring frivolous cases. It prioritizes patient protection, yet remains balanced for all parties. This approach is in line with how many U.S. jurisdictions handle malpractice. For example, Alaska uses a court-appointed expert panel to review cases early. Hawaii requires a pre-filing inquiry before a conciliation panel, but not an expensive arbitration panel. Guam's reform will be similar in spirit, encouraging early evaluation and resolution, but without the punitive cost of our current system. We will finally be bringing Guam's malpractice into the mainstream of American justice, while still tailoring it to our island's needs. I have heard the doctors fear that this bill will do more harm than good. I would like to explain to the people of Guam that all 50 states allow malpractice suits in court. All 50 states. And yet doctors still practice medicine in those places, often in far greater number than Guam. I also want people to remember that currently, under this arbitration regime, Guam has struggled to recruit certain specialists, a point even some doctors have made, noting that the protective law enables some generalists to work outside their specialty, undercutting incentive for true specialists to come because they know no accountability will be held for them. What we all should fear is a system that silently permits a few negligent providers to keep harming patients because they are protected behind a protected class, above the law, above accountability. By removing this blanket protection for bad actors, we improve the overall standard of care, which in the long run attracts good medical professionals and bolsters patient confidence in our healthcare system. Bill 82-38 is designed to screen out frivolous cases before they ever get to a costly jury trial. Our goal is not more litigation, but more accountability. The cost of negligence is already being paid today, but it is paid by injured patients and their families in the forms of disability, lost income, additional care needs, and trauma. When the legitimate claim is prevented by arbitration from ever reaching a fair resolution, those costs don't vanish. They are simply shifted onto the victim or onto public assistance and the fellow taxpayers. We all want to prioritize solutions that lower cost, especially for healthcare. And I submit that reducing preventable medical errors through accountability is one such solution. Fewer errors ultimately mean fewer claims and lower overall costs to the system. And finally, I want to point out that the current arbitration law has not demonstrably lowered healthcare costs for patients. Guam's healthcare costs are high and rising for many, many other reasons. Bill 82-38 is not about encouraging frivolity. It's not about enabling bad actors to continue in the system. It's about enabling valid claims to be heard. In fact, the pre-screening judge system is a robust filter against frivolous lawsuits. If someone tries to bring a truly baseless claim, it will not survive the preliminary stage. A judge will review the facts, likely dismiss it, and even possibly require the claimant to pay the cost of the proceeding for wasting everyone's time. There is a strong disincentive for frivolous claims. On the flip side, cases that are well-founded will now have a legitimate path forward, which is ultimately a good thing. I know the medical community has felt excluded from this proposal and urges collaboration on a better solution. I am not here to dictate an answer, but to find one. A legislative hearing is precisely the time to refine the proposal collectively. If our healthcare providers see specific provision in the bill that could be improved, I am open to amendments. I have always said that I believe bills that do not get challenged grow weak. So I welcome the medical community to challenge the bill, to make this bill as strong as possible, because when this bill passes, we will have a better system at the end. If additional safeguards can be added to prevent insurance shocks or to ensure the medical board is involved when malpractice is found, I am open to those ideas too. We have a legislative markup process for this very reason. I trust Chairperson Taitague and Vice Chair Terlahi will guide a thorough review of this bill in the committee markup, inviting further expert testimony and even holding additional public hearings after revisions if necessary. I am open to all of that. What I am not open to is no change. No change to the system that is failing our patients. My commitment to you is that we will get this right. We will not rush something that is half-baked, but we will also not indefinitely postpone justice for patients that have already waited for too long. The status quo is not a lasting solution. That much is clear. So let's collaborate in good faith to perfect this bill rather than using collaboration as an excuse to delay. Before moving on, let me say to all physicians listening, I value you. My wife, my child, and I trust our lives to you when we go to the clinic or hospital. Nothing in this bill changes the deep respect the community has for your service. We know you save lives every day, and this legislation is not an indictment of doctors as a whole. I believe that ultimately a system that openly addresses malpractice will strengthen public trust in healthcare to the benefit of ethical and competent medical professionals. I'm committed to a patient-centered approach that also takes into account the realities of our healthcare provider faces. And we will proceed carefully. I also remain open to complementary reform. My door is open to the medical community and association and any individual provider who has ideas on ensuring that good doctors are protected from undue hardship even as we hold bad actors accountable. Accountability and protection are not mutually exclusive. We can have both. In closing, Madam Chair, Bill 82-38 is about restoring faith in our justice system, faith in our healthcare system. It says that on Guam, we will not put any profession above accountability, and we will not leave any patient behind who has been wronged. It affirms that compassion and justice go hand in hand, just as we have compassion for those who are injured. We are just making sure that they have ways to seek redress. The current mandatory arbitration law was enacted with good intentions to curb cost. It has proven to be too one-sided and painfully unfair to patients without the financial means to actually fight this properly. Being poor or working class should never be a barrier to justice. I look forward to further conversations on this bill, and thank you, Madam Chair, for the opportunity to hear it. Thank you.
You're welcome, Senator Parkinson. At this time, I'd like to also, for the record, state that on BBMR, we received their fiscal note on March 19th, 2025. According to the comments received on Bill 82-38 COR, the Unified Judiciary of Guam is currently reviewing the attached legislation and has indicated to the Bureau that absent further information on the operational demands this bill may impose, the judiciary cannot determine a fiscal impact at this time. We also sent this bill to our legal counsel, who has reviewed with no recommendations, changes, or amendments at this time. Invites were sent to the Honorable Robert J. Torres, Chief Justice of the Judiciary of Guam, Corey Uggan, MSW, Executive Director, NASW, Dr. Alexander Wheeler, Chief Executive Officer, GRMC, Dr. Edison Manaloto, Chief Medical Officer, GMRC, Dr. John Ray Taitano, President of the Guam Medical Society, Gregory Woodard, Chairperson, Guam Board of Nurse Examiners, Nathaniel Berg, Chairperson, Guam Board of Medical Examiners, Dr. Maim Balahaja, Chairperson, Guam Board of Allied Health Examiners, the Guam Bar Association, Dr. Thomas Shea, President, Guam Medical Association, Dr. George Macaris, Dr. Gamili Batala, Attorney Robert Keogh, Troy Torres, Kandit News, Calvo's Insurance, Taitague and Associates, Cassidy's Association Insurance, Guahan Insurance, David Limboski, Nicole Flores, Dr. Ron McNitch, Monica Flores, Maria Espinosa, Monica Devora, Ken Leon Guerrero, and Anilin Largamis. Okay, and at this time, I would like to we have people that are on Zoom right now, and they were here very early, so we're going to have them testify first. Dr. Batala, I hope I didn't, sorry if I mispronounced it, Batalla. Sir, you'll be recognized first. Then we will have David Limboski, Sybil Chrysostomo. Please come to the table if I called your name, if you're here to testify. Scott Dula Bohan. This was oral testimony. I'm going to spell the last name, Dulebohn. Okay, please come to the table. Leanne, no, it's Lena. And last name is Leiscaman. You have oral testimony. Please come forward. Shadiah Constantine. You have checked off for oral testimony. Jay Sylvester. Vanessa Miller. Dr. John Taitano. Alves, Joanne Alves. Okay. Isa Santos. Asa Santos. Okay. Sullivan. Parma. We have also Sue, last name Sue, S-U, okay. Matten Cadwell. Wow. Oh, Dr. Akamoto. Couldn't read your handwriting. Okay, you're just here. There's nothing, sorry. Dr. Hun. Okay, Ginger Hanny. There, okay. I'm trying to get as many people on here as possible. Ramona Domin, Mitch Thompson, and I believe we have one more seat available for Dr. Thorpe. Okay. Usually, we're going to try and keep this be conscious. I don't like putting a timer on anybody's testimonies, but there is a lot of people here, and many of you have to leave right away to care for your patients and those who need to get back to their families as well. So please be conscious of your time. I do accept written testimony. If you're unable to finish within, a few minutes, then please feel free to submit your written testimony to my committee. I'm very happy to receive it. So at this time, I would like to turn it over to our Zoom, to Dr. Batala.
Yes, thank you very much, Madam Chair, for inviting me to give a testimony on this hearing. I am Gamaliel Bataya.
Okay.
I am a board-certified physician in pain medicine by the American Board of Anesthesiology. I'm now a retired physician, but I have practiced in Guam briefly last year. I would like to comment on Bill 82-38, taking into consideration my experience in the island. Currently, we are all focused about arbitration, but I think one thing that is not being addressed is the current definition of standard of care. So I would like to focus on this matter. Standard of care is defined on this bill as follows: the prevailing standard of duty, practice, or care by a reasonable physician in the same field practicing medicine in the community at the time of the alleged negligence shall be shall be the standard applied in the pre-screening, arbitration, and trial. Guam is a small island, and not everything available in the mainland is available in Guam. In many instances, availability of specialists is limited. Following this definition, if you are the only physician in your field of practice in the community, then you are the standard of care. In my short stint in the island, I have noticed numerous deviations from the standard of care in the mainland that is occurring in the practice that I joined, which I refuse to be a part of because of patient safety, ethical concerns, though some of them are also outrightly illegal. I suggest revising the definition of standard of care, setting a minimum standard in which physicians are held accountable. For example, there should be no excuse for not doing things that are available in the mainland that is the standard of care in the mainland. Otherwise, physician or a small group of physicians in the island would be free to set whatever they want to be the standard of care. Offering something that is not medically necessary or something wherein the risks far outweighs the potential benefits, perhaps for the purpose of financial gain, should never be considered a standard of care. This ends my testimony, and I'll be happy to answer any questions that anyone has regarding this.
Okay. Thank you so much, and thank you for your, making it kind of short. We do have a lot of people here. Next, I would like to recognize David Limbowski. Please state your name and your position and who you represent. Thank you, sir. I believe you're muted. David, you're muted.
How's that?
Oh, we can hear you now. Thank you. Please go ahead. Okay.
So sorry. All right. Thank you, Senators, for allowing me to give testimony in support of Bill 8238 and to advocate to improve health care on Guam through medical accountability. I arrived on Guam more than 50 years ago. I have worked at several social service agencies in the government of Guam. I am a proud University of Guam graduate. My work life includes working with the most disadvantaged individuals of all ages on Guam. This is what separates me from the others giving Bill 8238 testimony who want to keep the status quo Mandatory Medical Malpractice Act, or MMAA, intact. I have no skin in the game, so to speak, outside of having a dead 5-year-old child that died from very documented wrongful death medical negligence. unlike those with pure financial loss concerns, apparently. The people I speak of and why I'm here and who I am here for today struggle just to get by on a daily basis with no recourse to resolve the medical negligence allegation claims. No avenue to become whole again. They do not have $80,000 or $100,000 in their pocket to file the case, which is the estimated cost, if not more, under the triple MMAA. I have learned that people are often too embarrassed to write testimony or even challenge doctors when a loved one is injured or dies from alleged medical negligence, not to mention sexual misconduct. This is a big part of the reason that it took 35 years to get this issue of the lack of medical accountability caused by the triple MMA to be brought to light. This is where we are today. When the triple MAA was first introduced, as Senator Parkinson alluded to, it was done because of financial concerns. Doctors were doing too much testing. They were doing many treatments. They didn't want to leave any stone unturned. They wanted to make sure that all their diagnosis was correct and they couldn't be sued. Interesting, there wasn't that many malpractice lawsuits, but the financial burden of doing all those testing led to the enactment of the triple MAA to save money. That was a full pendulum swing in the opposite direction to lessen concerns doctors have that they may be sued if a misdiagnosis, which then now leads to less diagnostic testing and exposing patients to medical misdiagnosis, lack of proper treatment, and sometimes medical apathy, which is probably why all the clinics are closed this morning to protest this. Bill 82 is not about malpractice. It is not about poor people who cannot afford arbitration. And for sure, it's not about my son Asher. Asher's gone. There's been many, many since then, hundreds maybe. It is about having a fair, affordable system for all medical consumers on Guam to be able to have their claims heard and attempt to become whole again, to protect their rights, to improve medical care, and to protect the medical community against frivolous lawsuits. Guam has great doctors. I've had some of the best doctors in my life on Guam. But when great doctors protect doctors who have histories of negligence, that's where the problems stop. Medical negligence is stated to be the third leading cause of death in the USA. Statistically, it is estimated that 10 people die per month on Guam due to medical negligence. It is also estimated that 1% of doctors commit 32% of medical malpractice nationally. This number is likely much higher on Guam with no current medical accountability or ability to identify these repeat medical negligent doctors or to provide mitigation to prevent such negligent reoccurrences due to the triple MAA. And this one is very affluent. Guam is the only place, as was mentioned, in the U.S. that affords this kind of cover-up or protection. The biggest myth that we're going to hear today, and we've heard, and by the way, for 5 years we've been discussing this, the biggest myth is that Guam will not be able to recruit or retain doctors if Bill 82 becomes law. This is absolutely not true. No one has shown statistics or recruiting issues that will back this up. I have been in meetings here at the legislature in the past when doctors were asked if they would leave if reforms were passed. Everyone said no. I have asked Guam doctors, many, the same question on my own. All said no. And I think if you ask those doctors sitting there right now, are you going to leave if this is passed? They will say no, because there is no place to go that they have less accountability. According to Dr. Shea, in one of his Guam posts, Guam does not need doctors. We need specialists. The triple MAA makes recruiting specialists very difficult, as doctors on Guam are protected to work so that they can work outside of their own specialties. So when a new specialist arrives on Guam, he and she, in fact, must try to set up a practice not only with the small population on Guam, which makes it difficult, but making it even more difficult is that he or she must compete against other local doctors who are not specialists but have been practicing in the new doctor specialty area, making big bucks thanks to the triple MAA. Attorney Keogh in the 112 hearings called this malpractice in and of itself, working across trained fields into other areas. And triple MAA works against bringing specialists to Guam. As some of you know, presently there are serious allegations by one Guam doctor against another Guam doctor of doing procedures that may not be necessary with questionably trained staff using lower thresholds for prescribing treatments. The accusing doctor was told not to worry about malpractice when he was reluctant to do such things, such illegal things. He was told that no one would testify against him. These accusations, by the way, are documented, and some of you folks know about these. And they give a good example why the triple MAA has lived its life and why it has failed, and how the people of Guam may have been misdiagnosed, injured, and overcharged, all because of the protection that the law that everyone's sitting, and most people sitting there worships. Doctors come to Guam now with histories of medical negligence or sexual misconduct, and easily get licensed by the Guam Board of Medical Examiners. As much as they want to disagree. I've listened to almost every single board meeting over the last 6 years. They know they can work here without malpractice concerns, and cannot work anywhere else in the country. They are not even required to have malpractice insurance. Some of these doctors, as we know, then come to Guam and injure a Guam patient. The past Assistant AG Rob Weinberg for the medical board stated that Guam is known as a place where washed-up doctors can find work. Let's thank that on the triple MAA, the protections. The only part of this bill that I would change is to not have the Guam Board of Medical Examiners involved. I know that's a big ask. They have a history in their 70 cases under Dr. Berg over the last 7 years of never, ever deciding a favor of a complaint against a doctor. 70 cases, none decided in a patient's favor. Statistically, nationally, impossible. Dr. Berg, the chair, has gone out of his way in meetings with senators and in the past to make sure that accountability doesn't come to fruition. Also, they have a history of not acting on impartial off-file investigation reports paid for by tax dollars that find fault with doctors. In summary, this is what I think, and my research shows. In summary, the Mandatory Medical Malpractice Arbitration Act makes it more difficult to recruit specialists to work on Guam. It prevents identifying repeat medical negligence offenders and providing mitigation before others are injured or killed. It allows, the MAA allows for fraudulent and unnecessary medical care by undertrained staff or doctors, knowing they will not be held accountable. It correlates, the MAA correlates with higher costs of medical care on Guam, with no control or monitoring of unnecessary procedures. It prevents adjudication and claims as allowed everywhere else in the country to make victims whole again or take care of long-term medical issues. It gives the financial responsibility to taxpayers and insurance companies through medical services required to pay for injured victims that need care when they cannot seek accountability for the injury from the medical field on Guam, raising costs for the rest of us on island. And it definitely correlates with the demise of medical care on Guam. I'll end by asking one question. Would you pass Bill 8238 if you knew it would save a child's life or several lives on Guam? This bill is about saving lives, not saving money for doctors. Not passing this bill means we have to continue to sacrifice our loved ones on Guam. And there are clear statistics that support this. I just want to say one last thing really quickly. We've been talking about this in 2019. It's been 5 years. There's been two other attempts, Bill 112, and there's one before that as well, to make changes in malpractice. Now you have a group of doctors running around, closing their clinics, saying, oh, we didn't know about this, we didn't know about this. They've known about it. We've been talking about it for 5 years. It's all over social media. No doctor made an attempt to try to make a change so that consumers and injured individuals are taken care of. And then they're surprised that this Bill 82 comes up. This is not the last attempt. If this bill fails under the next government, there's going to be another attempt. And I would suggest to you folks in the medical community, sit down with consumers, not just your own people, and come up with something that will benefit everyone before the legislature passes a bill that you're not going to like. And I hope 8238 is that bill. Thank you very much, Senators. I appreciate it. Have a nice day.
Thank you so much, and thank you for joining us.
We got that dynamite. We got that dynamite.
Find the perfect ride for you today with the New Year New Ride sales event at Guam Auto Spot. Get behind the wheel of the 2024 Outlander Sport, starting at just $22,995 or only $156 per paycheck. Visit GuamAutospot.com or call 671-478-AUTO.